Jazzcast Pros.
Welcome to License to Love. I'm Lori McKnight, Executive Director of Families Thrive.
And I'm Veronica Black, Director of Program Services.
Together, our mission is to demystify the process of gaining your license to foster or adopt in New York State.
And to empower you with the tools, insight, and confidence to open your heart and home.
And here today with us is our guest speaker, Nicole Bayle. She does serve on our board and is quite a great supporter to this agency. So welcome, Nicole.
Thank you very much, Lori. Thank you, Veronica. Thanks for having me. I am a foster parent, adoptive parent, former foster parent and adoptive parent here in Monroe County, and I've worked in the family court system since about 2008. So I'm happy to be here today to talk a little bit about my background and the family court system and what foster and adoptive parents can expect.
We know that our foster parents typically struggle with learning what the legal process is for the placements that they have in their home. And of course, there's a wide challenge with understanding it and being able to navigate it. Wait, I got to say that again. There's a challenge for many of our families to navigate this system and understand why things and decisions are what they are.
I think that's pretty common for all of us as foster parents.
I love the fact that, Nicole, that you are able to speak to both sides, the legal aspect and your lived experience. But before we get into the legal aspect, can you share with us how many kids did you actually foster?
I started as a foster parent in 1999. So I was thinking about that this morning. It was probably about 27 years ago that I kind of stumbled upon this idea of being a foster parent. And it was actually through this agency that I became interested in this process. Back then we were called Children Awaiting Parents. And in 1999, I was working as an international recruiter for the University of Rochester. I was looking online back when the internet was still a little new. I was looking for a school called the Chinese American Preparatory Academy, I think. And I was trying to negotiate the World Wide Web as it was. And I ended up at Children Awaiting Parents, which had a similar website. And that's where I learned actually back in 99 that we photo listed children who needed permanent homes. At the time, my husband and I had a 3-bedroom house. We had 3 dogs, a couple of cats, and some goldfish, but we didn't have any children. And I went home that night and said, look what I found. There are these kids that need a place to stay, and we have open bedrooms. And I think at the time he thought perhaps I had lost my mind. But it sent me down a path that now when I look back, I really think was intentional. But at the time, I just kind of started to explore. So I looked into what it would take to become a foster parent, what it would take to become an adoptive parent, what it would take to get a home study. I ended up at an informational meeting for Monroe County. And from there, I ended up filling out an application packet. And from there, we ended up in the foster parent training courses. Back then, it was a 10-week program. So we went every Tuesday night to the classes. And we were certified to be foster and adoptive parents in July of 1999. We had our first placement was the beginning of August of 1999, a newborn baby who at the time he was about 4 pounds and the tiniest little thing I had ever seen. We brought him home from the hospital. We were incredibly ill-equipped to parent a newborn. We had to learn a lot, and my mom and dad came out and my husband's parents came up, and we had a lot of friends and family in our church were really helpful in getting us everything that we needed and helping us along the way. So that little boy we adopted when he was 18 months old, and he just joined the Air Force. He will be 27 this August. So he's an amazing, amazing kid and just such a bright light in my life. But since him, we have had, I think, just over 100 placements, formal placements, emergency care placements, long-term placements. And then we've had a few children over the course of our journey that we have taken legal guardianship from their parents, or their parents have asked us to help them for periods of time when they've been struggling. So with all of those kids, it's been about 100 placements in care. We have adopted 5 children, 3 or 4 kids that have been really long-term foster care placements that we had for a period of time that maybe went home but came back to us informally, and that have stayed with us through the time that they've graduated from high school, gone on to college, graduated from college. So it's a hard number to know exactly. I don't know how many legal foster care placements or informal placements, but it's roughly about 100 kids.
And you're well experienced when it comes to fostering older children and adopting older children. So it wasn't always just infants for you. Is that correct?
No, Kevin was the only infant. Kevin was that baby that we took in August of 99. He's the only infant that we've ever, well, had a couple other infants short term, but we've never had another long term infant placement. And all of our kids that we adopted were older. My youngest is 18 years old. We got him when he was 12, adopted at 14. My son, one of my boys, DJ, we got him when he was 8. He went home at 12. We got him back at 14, adopted at 16. He's 32 now. But most of our kids were older children.
Many of our listeners and our families, our very own families, don't understand the process, what it takes in order for a child to be removed from their birth family. What are some of the requirements or the standards? I don't know if that's the right word or not, but in order for a judge to remove a child, what condition or traumas have taken place in order for a judge to say, okay, we're going to remove this kid and place him into foster care?
So, and it's I think it's a tricky thing for parents and foster parents and adoptive parents for all of us, because it does seem often like there are children in the community that you hear about that should have been removed that weren't. Mm-hmm. Then there are other times that you hear of stories where children were removed and it doesn't seem like maybe they should have. Mm-hmm. And I think we all in this system, we all acknowledge that there are cases that sometimes don't make sense to us. Or sometimes when we look back, hindsight is usually 20/20, and we can look back and say, maybe we should have done something differently. Maybe we shouldn't have intervened where we did, or maybe we should have intervened differently. And there are a lot of things that play into that. But the general standard for a child to be removed from their parents is that they need to be at imminent risk of harm to their life or their physical safety. And that is a standard that Child Protective Services uses. It's a legal standard, and it's a really high standard. And sometimes, even when Child Protective Services believes that a child is at imminent risk of harm, they may be removed from a parent, but they may be able to go safely to another parent or to a relative resource. And we say relative resource, and people tend to think grandma, grandpa, auntie, uncle, but a relative resource is really anyone that the family identifies, or an older child identifies as someone who could be a safe resource for them. So sometimes the resources, well, we call them relative resources in the family court system, they may be a librarian or a teacher or someone from church or a neighbor or a parent's ex-significant other. It could be an aunt, but it could be someone that the children, I don't know about your family, but in my family, we called a lot of people aunt and uncle that weren't our legal aunts or uncles. They were my mom's best friend or my godmother, or, maybe it was my mom's cousin, but we always called her an aunt. So we use that term relative resource because we want to acknowledge that there are sometimes people who act in the capacity like a relative to family, but they may not be an actual blood relative. But they are a resource for a child to prevent them from having to be removed and placed into the home of a stranger, a foster parent. And so once there's been an assessment that a child is at imminent risk of harm, sometimes the Department of Human Services or Child Protective Services, whatever they're called in that community, will try to make a safety plan for a child so that they don't have to come to family court yet, so they can try to sort things out. Sometimes that's not possible, and some of our families just don't have resources in place that can help them out at any given time. And so children have to be removed and placed in foster care. The goal of foster care is always always to be a temporary place for a child to stay or children to stay until they can be safely returned to their family. And that is our primary goal, is to their parent. It's always to their parent, because we know that that's the best place for children to be if they can be safely there. And sometimes our families just need some additional support, some additional assistance, some additional help with housing or substance use or mental health issues or incarceration or illness, so that we can get our kids back home safely with the right supports in place. Sometimes it is a longer term process. So when they have to come to family court to ask for a court to basically order that removal continue, that placement in foster care or with a relative resource continue, then the county that has removed the child or children has to file a petition in family court. And there are specific timeframes with that, depending on whether or not a parent has agreed to the temporary removal or they have not agreed to the temporary removal. If a parent has agreed to the temporary removal of their children, then the county, whatever county it is, has to file within 3 days. If the parent has not agreed, they have to file the next business day. So if children are removed on a Thursday, we have to file on Friday. If they're removed on a Friday night, they have to file by Monday morning. So, and then it comes into court. And court can be different depending on where you are, but generally speaking, when it comes into court, the children are assigned their own attorney. The parents are all, and every parent is entitled to an attorney. And if it's a guardian that had the child and they were removed from that guardian, that person is entitled to an attorney as well. So you may come to court on that first day, and there may be a number of attorneys that you've never met before, attorneys that are representing the child who have never met the child, haven't had a chance to meet the child yet. But you have birth parents who need to meet with their attorney and talk with their attorney. You have the county that's removed the child, they have an attorney. And then you have the judge that's handling the case. And there are a lot of things that make that, that determine how that case goes. If it goes to a hearing or if there's an agreement for at least a temporary continuation of the child in foster care. And at that point, the parents are also given the option to come up with any other potential resources. Sometimes, especially in an emergency situation, a parent may not have an idea of who may be able to help them care for their child right then, but by the time they get to court and they're talking with their attorney, they may be able to come up with someone that they were able to get in touch with. Or maybe that was someone that they didn't think about, that they've known for a long time, but they weren't sure if they would be able to facilitate. Sometimes we have large groups of children. If you have 1 or 2 children, it may be easier for your grandparents or aunts and uncles to take on 1 or 2 children. But if you have 5 or 6 children, that's kind of a hard thing to take on, and to have the space in your home, the space in your car, the ability to get kids into daycare or into school from wherever they're living. Mm-hmm. And so it is, sometimes it's a process. And the county agencies and agencies like Families Thrive will work with a birth family to see if we can have children go to a relative resource, if we can give them some additional support, like daycare support or rides to school, or just support with getting beds, cribs, car seats, clothing. Those things, oftentimes when kids come into care in an emergency situation, we just don't have those things. And it's the county agencies and agencies like Families Thrive that work to try to support kids in that way. Once it comes into court that first time, usually after everyone meets with their attorneys, there's some understanding of what the resolution will be, at least short term. And then the case gets adjourned out. And at that time, it's really important that children have access to their attorneys, that attorneys for children are able to meet with the children, talk with the children, especially older children, about what they want, what they're experiencing, what they need, to talk about visitation plans, to talk about what visitation can be safe for children, if that's at an agency or if it's in a public place or if it's in a home or if it's in another relative's home. And it's important for the parents to be able to talk with their attorneys and work with their caseworkers to know what needs do we need to address right away so that we can get our kids back quickly. If sometimes it's something that's relatively easy to fix, like housing. They lost their housing. We need to get them better, safer, more stable housing. that's usually an easier thing to fix than a long-term substance use issue or a mental health issue that we need to get them back into compliance with their treatment goals. But we really, in the legal process, usually you see a judge and the judge's law clerk and the attorneys all really working together to see how can we get this family stabilized more quickly and what's the best way to go forward from there.
I have a quick question for you. When you're saying imminent risk or imminent danger, that word isn't always understood by everyone. Can you share more about what imminent looks like?
So imminent risk of harm is a legal term, and it's what they are required to prove in order to remove children. So if you go into court and the county says, we believe these children are at imminent risk of harm, and the parents say, we don't agree, then they do a hearing right away. That hearing starts that first day of court, and it continues every day court is in session until conclusion. And then a court makes the determination as to whether or not the children are at imminent risk of harm. But the legal term is understood, meaning that if left in the situation where they were, their physical and mental health would be immediately impaired or at risk of being immediately impaired. It's hard to give specific examples of that, but we see situations where children are left home alone for days at a time. I have two daughters who, when they came into care, they were 18 months and 4 years old, and they had been left home alone for multiple days. We don't know, they're little, so they're understanding of time, but they were at least able to disclose that they had gone to bed at least 2 times in a row without their mom being home. She had left them home. She had her own issues with mental health and substance use, and she had left the children home alone. So nothing bad happened to them because my daughter, who was just shy of her 5th birthday, was managing as best she could to care for herself and her sibling. But they didn't have food in the house. They were scared. And I think I have a hard time when I'm watching my 3-year-old granddaughter. If I go to the bathroom for a few minutes, I'm concerned that she's going to do something that puts her at imminent risk of harm. But so I think we all kind of understand that 2 children at that age being left home alone, they are at imminent risk of harm. They could wander out into the street. They could turn the stove on. They could do all sorts of things that put them at immediate danger. Now, if they were 14 and 16, I don't know that would have been the same, the same result. We have children that we find, sometimes children get out because their parents are struggling with whatever is happening in the home or in the family, and we find them in the street. And so there have been children that I've cared for over the years who have been found wandering the streets at 2, 3 o'clock in the morning. I think we would all understand that a 2-year-old alone in the middle of the street at 2 o'clock in the morning is at imminent risk of harm. Right. But often I hear people say, well, these kids, they've missed so much school and they have had lice and no one's doing anything. And I can assure you that's almost never the case, that the county is doing something. The agencies involved with the parents are doing something. But missing school and having head lice doesn't necessarily put a child at imminent risk of harm. Might it still warrant intervention of a family court? Yes. But likely being removed and placed into a foster care situation, probably not. But imminent risk of harm is a tough standard to understand. And it's really a judge that has to make that determination, whether or not a child's at imminent risk of harm.
Thank you. That was great. That's just, I think what our listeners and even we are glad to hear the details of what that looks like, and that we're not always just rushing to put kids in care. We're really scrutinizing what's going on in the child's life and what the actual danger is or the risk.
And I think we all understand that being removed from your parents, being removed from your home is very traumatic for a child. It's very traumatic for the parents as well, but it's really traumatic for a child. And so if we can, and you see this all the time, we will push in as many supports and services as we can to a family, including things like daycare or wraparound care around school or preventive services and respite services. We try to give parents the supports that they need to get their needs met so that they can safely meet the needs of children before we ever get to a place where we have to remove children because it's traumatic.
Definitely.
I know my current situation. I am a kinship care provider. I have my younger cousin. He's been with me for, I don't know, he's 18 months and been with me since he was 2 weeks old. And listening to the things that you're sharing with us, I'm basically experiencing it now. I'm on the back end of the foster care. So he's not actually in foster care. Yeah, he hasn't been removed solely. So, and that's because I came forward, right, as a kinship, as a cousin, right? So, with that being said, I do have a question as far as the time frame. I know during this whole process, they're working with the birth family, helping them get themselves together, providing the resources and everything, putting everything in place, and the kids are going back and forth for visits. Now, that time frame is ASPA, right? The Adoption Safe Family Act. Does that apply to kinship also? I know it applies for foster care. They, there's a time frame they give the families to, get themselves together and become stable and all that. But does that apply to kinship families also? Do you know?
So the Adoption and Safe Families Act was a law passed many years ago now. I mean, when I was a foster parent, it was pretty new, but now I think it was passed in 1997. And it basically says that if a child remains in foster care for 12 continuous months or 15 out of 22 months, then the county is required to file a petition to terminate the parent's rights unless there are some special circumstances or there's good cause to not do so. And the goal of that litigation or that legislation was to provide some level of permanency to children, because we know that for children to stay in foster care for year after year after year does not give them the permanency that they need to be able to grow and heal and move forward. So the idea was we need to provide a level of support to parents to get their kids back, but it can't go on forever. We can't be an 18-year process, right? Kids need permanency. We know that. With regard to kinship care, so there are children who are removed. They're formally removed from their parents, but they're placed in the care and custody of a relative resource under the supervision of a county agency, typically. And so those relatives have the right to become foster parents. And if they become foster parents, then, so the answer is sometimes. If those relative resources become foster parents and are in a place where they could then become an adoptive resource, then yes, then they are required to file that unless there's some reason not to, unless there's good cause not to. But if there are other avenues sometimes available to families through kinship resources that we try to utilize instead of a termination of parental rights. Sometimes we look at kinship guardianship, long-term kinship guardianship, where if the kinship provider you have to become a foster parent, be willing to become a foster parent, and the relative resource want to agree to that, then the child can be, or the court orders the child can be placed with permanent guardianship to that kinship parent. So someone like you, a cousin or an aunt or a grandparent, without the birth parent's rights being terminated. For an adoption to happen, the parent's rights have to be terminated either by a court or by surrender. And usually, and what's been my experience over the years as a foster and adoptive parent, but also in working in the family court system as an attorney for parents and an attorney for the Department of Human Services and as a law clerk, often these cases resolve if a child cannot go safely home. By the time we get to a place where a county is filing a petition to terminate a parent's rights, usually the birth parent and the foster parent have been working together long enough that there is a surrender, a judicial surrender that is executed. So in the case of, say, my son, Kevin, who is now 26, his mother signed a judicial surrender that allowed her to have ongoing contact. It was an open adoption. So she was allowed to have ongoing visits and updates so long as she kept us updated as to where she was living and where she was and how to get in touch with her. And she was required to basically reach out to us by phone or email to ask for those visits twice a year. And so long as she did that, she could have ongoing contact with him. And my son, DJ, who now is 32 years old, his was monthly visits. We had signed a conditional surrender so that she would have monthly visits. The reality for our situation with DJ was he was 16 years old. I had known his mom for many, many years at that point. We were bringing him to see her weekly, but the surrender was at least monthly. And I think we become foster parents because we want to help children. And what we see very quickly is that in order to help our children, we become a level of support to our children's birth families. And that means their parents, sometimes their grandparents, their aunts and uncles, their adult siblings or their other siblings. And so you take on a whole other family as part of your family. And you see that. And I mean, most of my friends who are foster and adoptive parents, that has been the same experience, that in order to be the best parent you can be to this child or these children, you become kind of part of their family and they become part of yours. And that means often shared holidays, shared Mother's Days, shared birthdays, because that's how our kids do best, is if we can support them that way. So by the time you get to a place where it looks like the legal system is going to have to intervene and perhaps terminate a parent's rights, usually we try as foster and adoptive parents to have created enough of a connection to a birth family that they trust us to care for their children. They trust us to meet their children's needs, and they trust us to keep them involved as long as it's safe and appropriate. And I think most of us, even if our children's birth parents have had their rights terminated by a court, we still try really hard to keep those parents involved as best we can and as safely as we can.
Nicole, during this whole process, there's that thing we call permanency hearing, right? What's the purpose of that? What takes place during a permanency hearing? Is that where they determine whether or not a kid can go home or how everything is going? What is that? Can you explain that a little better for our listeners?
So permanency hearings are required every 6 months that a child is out of their parent's care. And so every 6 months, as a foster parent or as a relative resource, you'll be invited to a case planning review meeting. And it's important that foster parents, pre-adoptive parents, relative resources, that we attend those, because they invite the children, they invite the birth parents, they invite the birth parents' attorneys if they want them to come, they invite attorneys for the children, they invite foster parents or caregivers. And it's where they talk about what the plan is for a child and what the plan is for a parent. So if your child is getting any type of services, whether those are in school or out of school, it's your time to bring those forth and make sure that those are accurately reflected in the paperwork. But it's also a good time to learn what are they expecting for this family? What are the goals for this family? Not just the goal of return to parent, which is always the goal, but what are the little goals to get there? Is it that mom and dad get safe housing? And right now we know that they are on a list for safe housing, but they haven't found housing yet. Is their goal to stay compliant with chemical dependency treatment? And are they doing that? Is their goal to attend parent-teacher conferences for the children? And how do we facilitate that? Is their goal to, if there's domestic violence between the parties, between mom and dad, is their goal to stay away from one another? And are they doing that? And so sometimes foster parents feel like those meetings, those case plan review meetings are critical to just finding out kind of what the status of the case is and how everyone's doing. But I believe that foster parents and caregivers really provide critical information about how the child is doing there. And even if older children can go to those, often children don't want to go to those. And sometimes we'll kind of have a bifurcated hearing. Or a meeting where the children are present for part of it, but not necessarily to hear all of the things that perhaps are going wrong with their mom and or dad, because they don't need to know all of that. From there, a permanency hearing report is generated by the caseworker, and those get sent out to the caregivers and the foster parents. Any foster parent that cared for the child for a period of 12 months. So if you may not be the first foster parent for a child, if there was another foster parent who had the child for a year or two before you got them, they'll get notice of that as well. And those permanency hearing reports go to the judge. And the judge looks at those and they schedule a permanency hearing. Those permanency hearings are usually, at least the first appearance is not actually a hearing, it's an appearance. And you go into court and the county says, this is what we want to do. We want to continue this goal, or we want to change the goal. The goals that are available for children are return to parent, and it's almost always return to parent initially and usually for the first couple of years. But sometimes a goal for an older child might be what we used to call an independent living goal, but now there's another acronym for it. But basically it means that a child isn't going to be adopted and may not ever go home, but we want to be able to facilitate them being able to live independently eventually with a significant connection to an adult. Sometimes once a child is freed for adoption, we'll change their goal to adoption. We sometimes will have a goal of a permanent, basically having a child permanently live with a relative resource. So the court will, and the county will say, this is what the goal is for the child. This is what we want the goal to stay. This is the plan that we are proposing that we continue for the next 6 months. This is kind of the status of where things are. This is how we've progressed, or this is where we haven't progressed, but we want to progress. And the parents, through their attorneys, can either agree with everything that's being requested, or they can say, no, we don't agree. We want a hearing. And the attorney for the child can do the same, can say, we agree, or maybe we can agree, but I also would like the court to add into the court order these services. Now, as a foster parent, this was sometimes the time for me the county wasn't always super happy with me here, because there were times that I wanted things from my kids, or my kids that were in my care, that I thought they needed in order to stay stable or to be able to go safely home. And sometimes if the county didn't feel like they had the resources to provide those things, or they didn't want to provide the resources to provide those things, I would ask in court things like weekly Taekwondo. The county would say, well, you get an activity allowance, and that $300 a year would cover about 3 weeks of Taekwondo. So I would ask the court to order that the county pay for Taekwondo. If I felt like a child needed, some kids come in and they have really specific needs that just can't be met by a foster family, like a special bed that they may need. We have some kids that are elopers who will get up in the middle of the night and they'll escape if they don't have a bed that actually has a tent contraption or some other mechanism to keep them in the house safely. And so sometimes those things have to come out at a permanency hearing. If the county doesn't want to facilitate that or can't facilitate that, the court can order it. For birth parents, sometimes they need help with a security deposit that maybe the county doesn't really want to pay, but the court can order that. And there are all sorts of ways that we can really tailor those permanency orders to meet the needs of a family. And I think it's critical for foster parents to go to those permanency hearings, because often a judge will say, foster parents, what do you think? How are things going? How's he really doing in your home? How's he doing in school? And those are opportunities for you as a foster parent to talk about all the successes that your child is having and what's going well and what other supports you think that they need. But the permanency hearings are where the judge sets the goal for the child and sets the plan. So what the parents have to do in order to have the child returned home to them, and they can order the counties and the agencies working with the families to give additional supports if necessary. And those are every 6 months, and they will continue as long as a child is placed out of their parents' care.
Thank you for sharing that. Now, we all understand the reunification process. We know that, the goal is always for children to return back, home with their birth family, just as you just said. So let's talk about TPRs really quick. Now, as our listeners know, we also have an adoption program here at Families Thrive. And what we do is, we meet with our families regularly, our adopted families, and we present kids to them. And then we come across some kids who they're labeled as legal risk. And that's because the parental rights have not been terminated yet, but the county or caseworker, they're searching for a family right now. And I know I'm jumping over to adoption, but it also applies for foster care. Now, I normally tell families that are looking to adopt, this can drag out for years because families have the opportunity and the right to appeal. Can you speak to that? Can you explain to us the TPR process, Termination of Parental Rights process?
There are two ways that the county typically will file to terminate a parent's rights. The first is by abandonment. The law is that if you as a parent go 6 months, 6 continuous months without contact, without meaningful contact, or supporting a child, then the county can file a petition alleging that you have abandoned the child. Those are usually relatively straightforward. We don't see those that often. They happen where a parent just disappears and we don't hear from them for months at a time. Or if they make contact, it's 1 voicemail or 2 voicemail messages left for a county caseworker, but they haven't seen the child. They haven't really had any meaningful connection. The other way is by alleging that there has been permanent neglect. And permanent neglect is a much more difficult case to prove, but it basically means that for 12 months or 15 out of 22 months prior to the filing of that petition, the parent has not addressed the reasons that the child can't be returned home, despite the diligent efforts of the county or an agency to do so. So the first part of the permanent neglect is that the county has to prove that the parent hasn't done what they needed to do to get their child back. They have not done the chemical dependency treatment. They have not done the mental health treatment. They have not done the anger management or the domestic violence work. They haven't done the work that they needed to do to have the child safely returned home. And the second part is that despite the diligent efforts of the county. So the county, the petitioning county, has to prove that they made every effort that they could to provide the support and the services necessary to get that child home. And despite all of those efforts, they still haven't been able to do so. And so those trials in family court, they take a long time because it's a long period of time that the county has been working with the family, and it's a long period of time to put in evidence as to what they've done and what the parents have done or not done. As you know, Veronica, and you know, Lori, but a lot of times families will do some of the work and then they don't again. And so it's just not as straightforward as, as birth mom never went to any visits and never went to any chemical dependency treatment. It's that it's hard to maintain compliance with that for the whole time. And so the county will sometimes wait to file a permanent neglect petition because a parent is doing better and it looks like they're on the right track, but then they're not again. And so sometimes we're talking, it could be 2 or 3 years before a permanent neglect petition is actually filed. Then, if the court finds that the parent has permanently neglected their child, then they schedule what's called a dispositional hearing. And at the dispositional hearing, the court has to determine whether or not they will terminate the parent's rights and free the child for adoption, committing the child basically into the care and custody of the Department of Human Services until the child can be adopted. Or if they are going to dismiss the petition and find that the county hasn't met their burden, or if they're going to what we call suspend judgment. So basically find that they have permanently neglected their child, but they wait a period of 12 months to actually go forward and determine whether or not the rights will be terminated. So they give the parents 1 more year, 1 more chance to do everything that they need to do. Typically, we will see that in cases where towards the end of the case, things have gotten better, or since the petition was filed, mom and dad are now engaging in all of the services. And so it looks promising. And so it's in the best interest of a child to suspend judgment and see if we can get back to a place where the kids could go safely home. Sometimes we do that because children are older and they don't really want to be adopted. They don't really want that as an option, and they really want to go back home. And we're hopeful that if we just give it a little bit more time, we can get there. If a parent's rights are terminated at the end of that whole process, after the permanent neglect finding, after the dispositional hearing, if a parent's rights are terminated, they still have a right to appeal. The appeals process goes from the Monroe County or Seneca County or Ontario County, whatever the family court is here in New York, it goes to the 4th Department, the appellate division. And that's a panel of judges that will review the case, and the attorneys can all argue their sides. And then they determine whether or not to uphold that finding that they permanently neglected the child or that their rights were terminated, or if they reverse it and send it back down to family court for further proceedings. But that process, that appeals process, can sometimes take up to 2 years because there's a lot of writing that goes into that, a lot of legal briefs, a lot that goes into that before the court can even hear the case, let alone make a decision. If a parent is unsuccessful at that stage and the appellate division upholds the termination of parental rights, the parent still has the right to ask for leave to the Court of Appeals, which is the highest court in New York. And the Court of Appeals can determine whether or not they wish to hear the case. That's pretty rare for the Court of Appeals to grant leave at that stage, but it's possible, and that can take a little longer as well. So the concept of legal risk was one that has been around for as long as time, but the risk is really all ours. And I say this in that there are cases where, my girls, for example, who are now 27 and 31 years old, when we got them, they were a 2-week placement. They had a relative who was going to take them. We didn't think we just need you to take them for 2 weeks. Well, that relative resource placement fell through. And then, after about 1.5 years, their mom was doing really well, and she looked like she was going to get them back. I mean, they were just about to start overnight visits at the YWCA, and then she disappeared. I think she felt very overwhelmed at the concept of having to be a full-time parent, and she made a decision to. I strongly believe she never was really able to verbalize this to me, but I believe she made the decision she did to leave the Y and walk away because she didn't think she could do it long term. And she couldn't sign the surrender. It was too hard for her. But she knew that if she walked away, that I would adopt the girls and they would be in the same place. And so she didn't sign a surrender, but she solidified what would happen.
She made her decision.
She made her decision, right. But I've had other cases where they say, oh, this looks like, maybe these parents have 9 other children and their rights have been terminated to all 9. And so it looks like this is going to go to adoption. And then maybe because the parent has matured, or they've aged, or they are in a different spot, or they have a different partner, they get their act together and they get that child back. So when we say legal risk, the reality is the risk is all ours. And when you think about that as an adult, any level of parenting, the risk is really all ours. And I tell people all the time, because often what you hear when you tell people that you're a foster parent, you've been a foster parent, they say, I could never do it. I couldn't give them up. I don't know any foster parent who has ever said, I'd be thrilled to just give this kid up. I mean, we don't want to do that. We want to be able to care for our children as long as we can. We want to be able to provide that level of support for our children as long as we can. And there are times where kids go home and we don't think it's the best option for them, or we don't think it's a safe option for them. But for me, I guess I've always looked at it that we are making as foster parents a lifelong commitment to this child. And this child is in no way obligated to make a lifelong commitment to us. They can't. They don't have the capacity to do that. They have no idea where their life is going to take them. And so I put myself out there saying, I'm gonna commit to this kid, whether that child lives in my home or visits with me on the weekends or calls me up once a year, or I never see them again. I am making a lifelong commitment to be a support to this child. And there are kids that I have had in my home that have gone home and it has broken my heart. And there are kids that I have had in my home that have left my home that I still think of every single day, and I haven't heard from them in 20 years. And that's what we do, because that's our role as parents. And is it for everybody? No. But these kids didn't sign up for this either. And I think the best that we can do is say, I'm willing to make a lifelong commitment to be a support to you, however I can do that. Whether that's you're in my home, you're adopted in my home, you're a visitor on holidays, or I never see you again, but at least you knew that when you were in my home, you were loved and you were cared for. And that's the kind of tough part of legal risk. The risk is all ours. And for me, it's worth it to know that at some point that child, even if they don't ever remember my name, or where I lived or how long they were in my home, that perhaps they have a sense that at some point in their life they were loved.
That is so beautiful.
Yes. Yes. See, we forget that Nicole is an amazing advocate, right? And she was an amazing foster parent. Nicole, you just provided some very, very important information. And I believe that all of our foster parents will benefit from just hearing that piece alone, because so many of them are willing to, adopt their foster children, and they don't really have that understanding of what the TPR process is like. So where we can say, hey, yeah, they're getting ready to do the TPR, that may not happen for, like you said, 2 years. And it may take a long time, and then the family appeal and all that stuff. So, I think what you just provided, and then based on your experience, I think was vital, and we really needed to hear that. I have another question for you. Can you share with us what legal rights do our foster parents have?
Sure. So foster parents,
In court proceedings, everything.
Yeah, you are absolutely entitled to go to court proceedings. And I always felt like it was really beneficial for me to be in court for two reasons. First of all, I always needed to hear for myself what happened, because as you know, in court it can be very confusing, and everyone walks out of there sometimes with a different understanding of what happened. When Kevin was a baby, I was a young foster parent. I was 25. I didn't really know what I was doing, didn't know the system that well. And I had 3 little kids at home, so I didn't go to court very often. And his birth mom would call me up afterward and say, the judge said Kevin's coming home in 6 months. And I would panic, freak out. Like, that's not what the caseworker told me. But it was her understanding. It was her lens. She was seeing it through, not necessarily the caseworker's lens. But I can tell you that the caseworkers sometimes don't fully understand what the legal terminology is either. And so sometimes it's important to be there yourself, to hear what is being said yourself, talk to other foster parents who may have gone through that, who may kind of know what some of the terminology is. The legal process can be very frustrating, because sometimes you feel like you go there, you sit there for 2 hours, you finally get called into court, nothing happens, it gets adjourned. It happens all the time. Because everyone has a right to an attorney. Everyone has a right to meaningful representation. And sometimes, and you know that sometimes people change their phone numbers or their addresses or their email addresses, or their attorneys, the agency attorneys switch every year. So you may get to court and you think you're on for a trial, and it just gets adjourned, and you think, I've waited all these months and now it's been 5 minutes and we're just going to leave. But it's a process that has to happen the way it happens in order to preserve everyone's rights, and make sure that the children are protected, and make sure that the court system did it the right way, so that if a court makes a determination to terminate someone's rights or to send a child home, that they've done so in the most planned, meaningful, safe way. And so we try not to rush those decisions, even though it's a frustrating process. We get that. But it helps to hear it yourself. It also helps, I think, as a foster parent, it's a way that we can go to court and have a meaningful connection with our child's birth parents, because the reality is that whether you're doing 50-50 or 75-25 or 99% you're doing and 1% birth parents are doing, we're co-parenting, and you're going to be co-parenting as long as you're alive, because it doesn't matter how old your kid is. I have kids in my 30s or in their 30s, and I'm still co-parenting with their birth parent. And I'm still navigating some of the decisions that were made and the trauma that happened. And so that's our reality. And so for me, going to court was a way that I could align myself with my kids' parents and say, look, we're in this together. And we may, I don't want you to see me as the enemy here. I want you to see me as someone who's here trying to just do what's best for this child. And so I always sat with my kids' parents, and the whole way I always sat with them in court, because I wanted them to know that I was on their side and that we were trying to do what was best for this child together. And as I aged as a foster parent, I got better and better at that. I wasn't real good at it at 25, much better at it after 20 years. But it's important, I think, that because caseworkers are doing great work. They are. And 2 of my kids are CPS workers. They do great work, but they only have so many hours in a day. And the reality is we're parenting these kids 24/7, and we're co-parenting with birth parents 24/7. And so I thought it was a helpful time to be able to ask questions. It was a helpful time to be able to share stories and pictures. And it was a helpful time to be able to show we're in this together. And I think that building those relationships and those connections is incredibly important to our kids. All right, so let me say this. After a child's been in a foster parent's home for 12 continuous months, you have the legal right to intervene. You have the legal right to get an attorney and intervene in that proceeding. The reality is that sometimes, and often it does help to have an attorney, because often they'll have attorney conferences. The attorneys will meet together with the court. So it does help. But it's not really necessary unless you feel like your voice isn't being heard. Right now in Monroe County, we have a very strong bench. We have a group of judges who I think really prioritize the health, the safety, the well-being of our children and our families. And I feel really confident saying that because I know all of them, and all of them have worked in this field for a very long time. We have a very strong panel of attorneys for children who are fierce advocates for our kids. I'm not as familiar with the other counties in the 7th Judicial District and their family court system, but I know that the work that is done in family court all across New York State, it's a place where we are really working hard to prioritize family court. Our chief judge here in New York has worked very hard to prioritize family court, and his entire State of the Judiciary address this year was about family court and the family court work that's being done in New York State. So I feel like right now is a time where children and families are really being prioritized.
That is so good to hear. It really is.
It is. It's refreshing.
Yes, very much so. We've had some great conversation. Like, I think we could listen to you for the next hour or two. There's just been such good information. We've brought you in the past to speak to our families because of your knowledge base, your experience, and just listening to all of this process that you're providing us information with is so helpful. And even it's good to hear, even though we've been doing this work together for a long time, I think it's good for us to hear as well some of the processes so we can give our families a little more support around it. But it helps everyone to understand more what's really going on behind the scenes as well. So we're so appreciative of you being here. Thank you. Thank you for the information. And we hope to have you back. I think there's a lot more to talk about. Yeah.
Yes. So thank you so much.
Thank you for listening to License to Love.
If you're curious, cautious, or already in the process, License to Love is your roadmap on this journey.
Every child deserves a safe, loving home. And we're here to help you gain your license to foster and adopt. Follow License to Love on the Jazzcast Pros Network, available wherever you get your podcasts.